Okay, everybody, thank you all for joining us and welcome to the BrandBar Happy Hour chat. I'm excited to have with me today Karen J. Bernstein from Bernstein IP. How are you today, Karen?
I'm hanging in there. Yet another little bit of snow in New York. Just can't get enough.
Yeah, I know. It's really cold there. I had a visit once and I felt like every time I stepped out onto the streets of New York that my lungs literally froze. It was, it was really cold. So
Let's
Karen,
talk about it.
I was thinking maybe before we jump into asking you all these questions about how we can protect ourselves, you can tell us a little bit about you and Bernstein IP.
Well, Bernstein IP was recently rebranded from Karen Bernstein Law. The law office is a Karen J. Bernstein, and I've been on my own as an IP attorney for August of 2007, so we're coming up on our 8th year. I've been practicing for 14 years. I worked at another boutique intellectual property firm where I really learned all the ropes for 6 years on Park Avenue in New York City, right out of law school. I have a music and advertising background. I'm a published songwriter. I co-wrote a song, a disco hit, a long time ago when I was 19, and I also was in advertising before the internet, and decided to combine the two to become a trademark copyright lawyer. And while I was in law school, it was late 90s was when things were really heating up with the changes in the law. The Uniform Dispute Resolution Policy was enacted in 1999, so I was in law school at the time, and I wrote a lot about online issues, not just with domain names, and what it really wasn't about domain names. I wrote about music copyright infringement online and various things going on online because it was hot at the time. So coming out of law school, starting at Amster Rothstein, the firm that I was with, they had clients like Macy's and Ralph Lauren and Calvin Klein, Bloomingdale's, and so what we were doing is representing them. And of course, back in the day, people were pretty wild, and they were registering domain names like Bloomingdale's .net and trying to hold them for ransom. And the UDRP was pretty new, and so I was straight out of law school doing domain disputes on behalf of trademark holders. So I learned a lot about that. I did some pretty cool copyright work. I worked for another firm for about a year. This famous entertainment firm. We successfully defended a preliminary injunction for somebody was trying to sue the composer of the theme to Breakback Mountain at the time, and we were able to beat it because, you know, it happens. People think that songs are stolen, and in fact they're not. They're usually common themes within songs. It's really hard to prove copyright infringement. So I've handled some music cases, trademark cases. I have all kinds of clients. Majority of my clients are in the internet business. They're either have the latest, greatest mobile app that they're putting out there, they have a website, or they're actually cctlds.me. I'm their outside general counsel. So I've worked within the ICANN procedures for new GTLDs. It's kind of evolved over the years, and I really enjoy it. It's a really interesting interesting industry and interesting area of the law. Investors I've been working with since '07. The person who brought me into this industry was Mark Ostrovsky, and I don't know whether you know who Mark Ostrovsky is.
Absolutely. I read his book. That's how I started in the business.
He brought me into it. He found me online. He liked me, and he said, "You need to get on a plane." This was like 2007, and go to traffic in Vegas.
Wow.
I had no idea. I mean, I was always working on the trademark side. I didn't know that domain investors really existed, that it was legitimate, it was for real. And so I got on an airplane and flew out there and met Lorianne Wardy, who's now the vice president of .co. Was one of my first clients that really came out of the domain name industry, other than Mark. So I'm very humbled that I was just at the right place at the right time. So
That is amazing. That's a little bit of how I feel. I was at the right place at the right time at that UPS shipping store when I saw Margot Strotsky's book. And I read that book, and that's what started me on my journey here, believe it or not.
Yeah, that's
So,
great. I filed a trademark application for that.
did you? My goodness, what a small world it is. But this community is a really small and tight-knit community, and that's what I love about this business. So let me get us started by asking you to, I guess, tell us what are the most common legal issues that we as domain investors are usually faced with.
Well, domain investment and stuff. What exactly are they doing with the domain names? What's your business model? Are you buying domain names and building out sites as opposed to monetizing them through links or park pages? Are you looking to cash in and make as much money as possible? And all these are considerations, but you also have to consider, obviously, when you're buying and selling domain names actively, whether you might be unwittingly violating someone else's trademark rights. And you can think that you have a pretty generic or descriptive domain name, but there are trolls out there who will try and hijack your name, particularly if it's highly valuable. What may seem like, for example, I made some notes, Apple.com, right? If you owned Apple.com and you parked it with pages for computers and software, well, you're probably going to be setting yourself up for a lawsuit. But if you were using Apple.com to, I don't know, talk about apples, apple pie, all sorts
Apple
of things
recipes.
related to the actual Apple recipes, and you don't have any ads on there for computers and peripherals, you're probably in the clear because you're not doing anything. So it's really all in how you use the website, not the actual name. I mean, does it make sense, for example, for you to know if you have a highly descriptive domain name, does it match a trademark holder's name? And so what do you do? What sort of steps do you do to try and mitigate the possibility of getting sued?
Okay. Well, you know what? You mentioned the trademarks and steering clear, I guess, of trademark infringements. But for those of us, well, I think most of us here know what a trademark is, but there may be some listeners who don't know. So if you could tell us what it is and maybe give us some more examples of the types of trademarks that we should probably be aware of.
Well, trademark is when you use a name that's connected to a product or service that you're offering. And so that's the basics of what a trademark is. It's your brand name. You could be a psychiatrist, or you could be selling apples, for example. So what we basically do is we define strengths of trademarks and whether or not they. So going with the strongest type of trademark that's out there is a made-up word. We call them coin terms or fanciful. So things like Xerox, Kodak, they weren't real words at the time. So if you're making up a word, that's the strongest sort of trademark that there can be out there. Then you move on to what we call suggestive trademarks. Well, let me back up. Move on to an arbitrary trademark. An arbitrary trademark, using Apple again, Apple for computers. It doesn't have apples have nothing to do with computers. So BrandBar for a talk show or a chat site that talks about domain names and their significance, that's a little bit more arbitrary. Not the greatest example, but I think you get the idea.
Yeah.
Then the next descending or lesser or weaker type of trademark is called a suggestive trademark. And a suggestive trademark is some good examples of a suggestive trademarks are like Greyhound for a bus, because it connotes a fast sort of animal, a dog. And of course you have Jaguar for cars, and they're extremely fast. So you kind of have to use some mental leap to go from what is the brand and what the product or service is being offered and make that mental connection. Then you have the one type of trademark, and it's not a very strong type of trademark, but it really centers around domain names, and our particular of interest to this audience is a descriptive trademark. And descriptive trademark pretty much says what it is. Now, a classic example is Computerland. I mean, you know what you're going to find. The minute you hear that, you know that it's probably going to be a retail store for computers, or bed and breakfast registry. I mean, it doesn't take really any imagination. Contrasting that with suggestive trademarks, which is where you have to use your kind of a mental leap to get there. Descriptive trademarks are, how is the domain name being used? Is it being used as the website at the domain name being used in a very descriptive way? So if you had, goldcardsforsale.com, and you're offering nothing but gold cards on your website, I'm making this up, or goldcoins.com is probably a better example, and all you're doing is offering different types of gold coins. It's extremely descriptive type of trademark, and chances are you're not going to get a U.S. federal trademark, and so it all comes down to how you use the website. Now, if you've got pay-per-click links, you can run into some serious problems, because lots of those are algorithms that are generated by a computer, and if somebody owned gold coins for a clothing, I'm making this up, and you had pay-per-click links for other clothing companies, you could get in trouble, and they would be able to go after you, and you'd probably lose. So it's really important that, number one, when you're using parking, if you use park pages, I would personally and professionally say that you should see whether the park company has any sort of way to put in negative keywords to avoid having those types of ads come up. And that requires doing research on your own. We'll talk about how you can kind of look up trademarks on your own, and not total detail, but especially if you have a really valuable domain name, it might make more sense to come to somebody like me, who's a trademark professional, who can do an assessment, figure out if there's any other trademarks out there, and give you advice on how to use it. But to do that for every domain name you own is just going to be too expensive.
Yeah.
So, and then the least, we all know the weakest type of trademark is a generic mark. I mean, that's just like flowers. You know what flowers are.
Right.
So those sorts of descriptive and generic marks, generally, nobody can claim an exclusive monopoly on words like company, service. So that's pretty much it in a nutshell.
Okay. Well, you're really good, Karen. You really helped me with this, because you took me to the next question, which was going to be, how can we make sure that our domain name, or potential domain name, I should say, is not a trademark or a potential for some kind of a trademark infringement suit?
There is a trademark database called that WIPO has. In case anybody doesn't know who WIPO is, it's the World Intellectual Property Organization. That's one of the administrative bodies who actually preside over domain disputes, other than the National Arbitration Forum. There's another one in Czechoslovakia, the CAC, and I believe there's a Chinese one as well. But World Intellectual Property Organization has a great database of trademarks worldwide that you can look up. And it will tell you, hey, if I own gun store, I'm making this up, I can go on this. It's just a searchable database. I warn you, though, when you go on there, you're looking at exact hit searches, and trademark law looks at confusing similarity. But it's best that you do something like that before you register the name, and especially if you're going to spend a lot of money on it. It also helps to go into your country's trademark database, because remember, trademarks are country by country. So what I would do is I would go and I would look up whatever the name is that you're searching, and whatever the results are. If nothing comes up, I'd take a screenshot of it at the WIPO trademark database. If I went to the U.S. trademark database at uspto.gov, took a screenshot if there were no results, so that it would be a partial defense in a domain dispute that you did do some sort of due diligence before you registered the domain name. So that's one. Those are two things you can do. I could probably provide Angela with the link to the WIPO trademark database and the USPTO, if that's technologically possible, Angela. Maybe we can throw it up. Facebook
Yeah.
page,
Yeah, that'd be
you
great.
guys?
I'll hang it on the page with the video.
Right. So you want to make sure that you're covering yourself. You're doing some due diligence. Run a Google search isn't everything. I mean, that's always recommended that you do that prior to registering the domain name. Now, if you're picking stuff up on the drop, that's probably going to be a little harder for you depending on your business model. But you're going to spend $15,000 on a domain name, or 5,000, whatever you consider highly valuable. You want to do your homework. Make sure also that the domain name you're buying isn't stolen, because stolen domain names are becoming so much more prevalent. I actually had somebody who came to me a few weeks ago and said, would I like to broker, because I do brokering too, would I like to broker this particular name? I looked it up and I could see from who is historical records that there was something fishy about it, and I had to tell the guy, I'm sorry, but this domain name is stolen. He said, oh my God, I just spent X amount of money on an auction and got this domain name, and here he is sitting there with a stolen domain name. I'm not going to represent him to broker a stolen domain name. I offer to help him maybe try and recover, go to the owner, and maybe contact them and do a deal with them, to get the domain name back. So be careful out there.
Okay. So Karen, should we file for any marks or trademarks on our domain names or monikers even?
Yeah, well, here's the thing. There's a common misconception that registering a domain name automatically gives you trademark rights, and that's not true. Remember, in order to have a trademark, you actually have to be offering products or services. So to a certain degree, in the U.S., of course, we're a common law jurisdiction, just as England and Australia, New Zealand, Canada. It's the first to use the trademark that usually wins, not the first to file in trademark office. And in the U.S., and I can only speak for U.S. law, and you have to actually show or prove to the trademark office that you're using the mark. So, I've seen instances where people have been able to get trademarks on their domain names for offering advertising and marketing services when they have links on their websites. That's one way to do it, to protect yourself so that you have a trademark. But if you get a descriptive trademark and you're offering what your a descriptive domain name, and you're offering what your domain name says, like guns for sale, and it's all about guns, chances are you're not going to get a trademark on it. So it just depends on how you're using it. Once again, of course, you always can come to people like me, who's a trademark professional, to give you advice on it.
Okay. Now, there have been cases where someone does, I don't know, I don't want to say purposely or not purposely register a domain that might be considered a trademark or might have some kind of dispute that's going on with it. And they might receive a cease and desist letter from a lawyer's office. What should they do? How should they respond if they receive that? And also, do you necessarily always receive the cease and desist when you're, kind of hanging on to somebody's name or maybe using it in a way that you shouldn't be?
Yeah, there's no hard and fast rule. Some holders or supposed trademark holders, because there's lots of trolls out there too, may not send you a cease and desist letter. They may just either bring you into court, sue you, depending on how much money they have, or they'll file a domain dispute against you. There's no warning whatsoever. Others, on the other hand, they may send you a cease and desist letter. So if you encounter a cease and desist letter, and in particular, where it's an email, in particular from a lawyer, I really strongly suggest that you get a lawyer. I know it's going to be terrible and you're going to have to pay some money, but you do not want to have a conversation with another lawyer, because we're specially trained and we know all the tricks and the ins and outs, and we can actually bluff about certain things. We're allowed to. And if you don't have the sophistication as much as you think you might to talk to a lawyer, you're really not on the same level. And I've seen instances, unfortunately, where my client turned over a domain name to another lawyer, a big-time troll lawyer, And they wrote him a check. It wasn't a whole lot of money. He just said, pay me my out-of-pocket costs. And they sent him a check, and then a month later he accidentally registered another domain name, and it was an accident. And at that time, they just went ahead and sued him in federal court, and he didn't know what he was doing, and he unfortunately was traveling outside the country, and a default judgment came in for him in federal court, and it was to the tune of something like $250,000. And the reason was that the troll lawyer was able to tell the court that my client had infringed on his client's trademark with the domain name that my client gave back to him, and they got the maximum statutory damages for an anti-cyber swatting Consumer Protection Act of $100,000.
Wow.
So had there been, and that was just one of the domain names, had there been a lawyer like me intervening and dealing with this, number one, the case probably would have gone away, and at the worst, probably would have gotten the minimum statutory damages of $1,000. So you got to be really careful.
Well, now that you mention that, that makes me start wondering what we should do as domain investors to protect ourselves, especially our personal assets.
Yeah. Yeah. Well, I can tell you, I'm not a business formation lawyer. I work with a network of other lawyers. I work with patent attorneys and business attorneys who do securities law, and they know formation, but this much I know. If you own the domain names in your own name and you get sued, they can reach, if you can't afford the amount of money that you might lose on a case, or they can reach into your pockets. They can, garnish your wages, maybe take some money out of your bank account. There's certain limitations because there's a Consumer Protection Act involved. They can't take your home away from you. But if you have other properties, rental properties, they can put liens on them and sell them at a sheriff's sale. So you really are better off forming some sort of corporation or limited liability company. But I warn you that if you do, you do not want to use your corporation or your LLC as your own personal piggy bank. You want to have a separate operating agreement. If you have other people that you work with, you probably want to have an employee payroll, pay separate taxes. Whatever you use, personal use is your own checking account, just like you work for someone else. That other company is someone else. So, and that way they can't accuse you of being what they call the alter ego of your company or your LLC, and then they can reach into your personal assets. So, best to talk to a business formation attorney about that. And I know a few if you need a reference. And that's about all I can say about trying to protect your assets. The other thing you probably want to be able to do is make sure that you've got someone out there that your loved ones know your usernames and passwords for your domain controls. God forbid you die or something happens to you, in lieu of a will, at least they can go into the domain control and they can renew your domain names. You spend years and years developing your domain names, building up your business. You don't want that all to go away when you pass away. And you certainly, if you have children or other loved ones, you may want them to have the domain names. So they're real important. You could talk to an estate attorney, but there's also the username passwords. You should have someone really trustworthy, or put it in a safety deposit box, or somebody's got a key, something like that, so that you don't lose your domain names.
That's good. That makes me think: are domains willable assets? Because can you actually say, I guess, can your children inherit them?
Oh, sure. I mean, I'm not an estate attorney, but like anything else, if you have, it's a contract right in most states. It's only in California and Washington State that's considered property per se, but intellectual property is not a tangible asset. You can't hold it in your hand, and that certainly can be willed. I would think that there is a way to put together a legacy sort of situation with an estate attorney who knows about internet issues. That's a problem, but somebody who's bright enough who can help you, you can look into that.
Okay. So let's just say we happen to get sued, or we get a letter in the mail or an email, and I mean, it's on. A lawyer has contacted you, They have told you they're going to file suit. You get some information in the mail. It's clear that you're being sued. What do you do? How do you respond? You know, what is your next step at that level, at that point?
Okay. This preliminary issue, we were talking about LLCs and corporations. Most federal courts have a rule that says that you cannot represent your own company or your LLC. And you can represent yourself, but I would, if you're individually sued, I highly recommend that if you get sued, you go to a lawyer. You know, in some instances, not in all, if you own a home, you may, and I say may, be able to use your homeowner's insurance if the domain names are in your personal name to try and pay for your legal defense. Sometimes it happens, sometimes it doesn't. In some states, advertising, trademarks are considered a form of advertising, and they're usually excluded. But perhaps a homeowner's policy will help you. It may not get you the lawyer you want. That's the only downside. But if you're in a financial crunch, the other thing is you might, as a corporation, I would highly recommend it, not even might, you should. If you form an LLC or a corporation, you should get a commercial general liability policy. It's what we call a CGL. You can shop around and make sure it doesn't have an exclusion. A lot of them have exclusions for advertising. It depends on the state. But take a look at it, because it also, they'll cover you for copyright. So that's one thing that you can do. If you get sued, you really need to go to a lawyer. For one thing, do not run away. Don't try to delete your domain names and think the whole matter is going to disappear. Don't try to transfer your domain names to someone else after there's a lawsuit. That makes it look even worse. Best thing to do is not destroy anything. Don't touch the domain name. Don't touch the website. Go to a trademark professional internet lawyer like me who'll give you the proper counseling on what needs to be done. If you don't, the problem is that you might wind up suffering what my client did, which is a default judgment, and it tarnishes your reputation, brands you as a cyber squatter, can really make your life miserable financially if they get a huge default judgment like that. My client, by the way, when he brought me in to the case and the default judgment, we settled it. We were able to settle it with him, so he admitted no liability, didn't do anything wrong. But that's kind of after the fact. Anybody looking at the record, they would have to look into it. The settlement agreement's not on the docket. All they know is that it was settled. So you don't want to suffer a bad reputation, and you don't want to lose a lot of money. And you have to think to yourself, well, I can't afford to pay a lawyer. Well, can you afford to pay a $250,000, $300,000 judgment? Yeah, if it's a lousy domain name and it's not worth anything, you go to the lawyer, and the lawyer says, this is a terrible domain name. This isn't worth it. Let's try to cut a deal and get you out of the case. But God, do not run away from it, as it's just going to bite you, and it won't be a good thing for you down the road.
Okay. So let me ask you about one other major thing before we open this up for everyone else to kind of get in here. I'm sure they have some questions for you. There is one big thing that has been, I've seen published so many times, these U-drop decisions, or UDRPs. Now we're going to have some listeners who know exactly what that is, and that probably be us in this community, but there might be some who don't. Could you tell us, walk us through what it is, and tell us basically how do we respond if that happens to be something that we're going to be experiencing? If we happen to actually get that notification in the mail, what do we do?
Now, first of all, you'll be emailed a warning, or kind of a heads up from the arbitration company. They're a national arbitration forum. Mainly they're the bigger ones in the uniform. WIPO will send you an email and say, there's a complaint that's been filed. We're checking it out to make sure that's in conformity. So you get about 45 days heads up to find yourself a lawyer. There's a certain amount of cost-benefit analysis with a UDRP versus a court case where there's money involved, because that's the remedy in court, is they get the domain name and they get money from you. And UDRPs, it's either transfer the name or what they call cancel the name, where basically I think it's a stupid remedy, but I would never recommend it to my trademark holder clients that they go and get a domain name canceled, because what happens is It means it then goes back out on the open market. But the only remedy is transfer denial, the complaint where you get to keep the domain name. In that case, you've got to do an analysis. If it's a crappy domain name, it's really, not worth fighting. You might be better off just doing nothing and let the panelists decide and transfer the name, But if it's a name that's really, really important to you, that's worth a lot of money, look, I've known some domain investors who've been able to successfully defend themselves on their own in a UDRP. They give it kind of a model form you can work with. Are your chances of winning higher if you use a lawyer? Yeah, because we know how to cite to cases. The panelists are also practicing, most of them are practicing trademark lawyers. And most of them are practicing trademark lawyers for trademark holders. So they're going to be less inclined to help you out. But if they see a good argument and they see a lawyer behind it, it can tip in your favor. The other thing that I always recommend is usually the complainant will, that's the trademark holder who was plaintiff, will just not do anything as far as panelists. You get single panelists, whereas the respondent or you or the defendant, you can actually elect a three-person panel, and it's better for you to do that when you're the defendant because 3 heads are better than 1. You got 1 person who's determining whether or not to give away your domain name. You might as well have 3. So I'm going to tell you, and of course I'm a lawyer, I'm going to say go to a lawyer, but really, if you have a heart attack, do you just handle it on your own, or do you go to a doctor? We're trained especially to do this. Also bear in mind, if you lose a UDRP, you do get 10 days to appeal it. So you get a choice of jurisdiction, either where you are located or where the registrar is located. You can go there and you can stop the domain name from being transferred, and then you're in federal court. So sometimes you can do really well, but it all depends on how valuable the domain name is and what you want to do with it. It's more of a business decision. Of course, if you start getting sued in UDRPs and you keep losing them, I think you probably want to start rethinking your business model because you'll be labeled a cyber squatter, and it makes it a lot easier for people to take domain names away from you.
Okay. Karen, I've been monopolizing your time, and I think that we have some members here who might have some questions. So I'm going to open up the mic and get us started with that, because that's always a fun part of our show, hearing what everyone else thinks and getting feedback and questions from them. If you have a question and I haven't unmuted you, you can also put it in the chat window here, and it's kind of like a raising your hand deal, I guess, so that way all the mics aren't open at once. Let's see. Does anyone out there have a question for Karen?
Yes, I do. Adrian.
Okay, Adrian.
Hi, Karen. How are you?
Good. What can I do for you here?
Yeah, so first off, thank you so much for coming on today and giving us your expertise. And it's very valuable information, so thank you very much for that.
Right.
If someone wanted to, and I'm sure you may touch on this, but what are costs for a lawyer such as yourself in the event that someone needs to contact you? What are some low and high numbers that we would be looking at to bring you on staff?
Well, it depends on what you're using me for. You said on staff.
Well, maybe not on staff, but if we needed to have your expertise or for you to represent.
So find that if I
You mean we can't just have you on retainer for everything?
You can pick up the phone and call me if I've got a problem, and I'll say, what is it?
Hang on one second here, Karen. Let me unmute everyone else again, because we're getting a little feedback, and I couldn't get we need to hear your response. Just give me 1 minute. Let's see.
So I guess some.
Oh, we still got some coming in. Go ahead, Adrian.
Yeah, no, I guess maybe not on staff, but if someone were to get a UDRP, or if someone needed to have you as a retainer, what would that look like?
Well, I mean, on certain circumstances, I'll charge a flat fee, and others it will be an hourly. It just depends on the deal. But if you're asking what my hourly rate is, it's $400 an hour. If you want to have a 1-hour comprehensive consultation, it'll be $400. If you're talking about UDRP, they range anywhere from $5,000 to $7,000, depending on the situation. You know, if you're looking at a retainer, they can go anywhere from $10,000 and up. It just depends on what you're doing. I've charged clients on a monthly basis, depending on whether they want me on staff, that sort of thing. So it all depends on what you want to do. I mean, you know, flat rate trademark services are going to be cheap. If you're talking about asking for time and expertise, yeah, I mean, pretty much in that range. Now, that's why I say, in particular, is that although you know, people shy away from the money factor, it's that in the long run you might wind up just paying even more on the back end. So, you know, everybody knows lawyers aren't cheap. But, you know,
Sure.
we can always, depending on what your situation is. How much trouble are you really in? How much work is going to need to be done? Those sorts of things. It all depends. Anybody have a legal question?
I have a question.
Go ahead.
Hello?
Yeah. Yeah.
Hi, my name is Aaron Pace. I'm a brand owner, and I have a question for Karen.
Oh, hi, Aaron.
Hey, Karen, how are you? Good to hear you today.
Thanks.
So, good. I understand that are you working with ICANN now? What do you, tell me about that.
Well, ICANN, for people out there that may or may not know what ICANN is an Internet Corporation for Assigned Names and Numbers. And what they do is they pretty much govern the way that they're kind of like the UN for the Internet, is what I tell people. They create policy. I'm actually a member of the intellectual property constituency. It's a group of mainly brand holders and trademark lawyers, but there's a lot of us domainer. There are a couple of domainer attorneys like me in there too, and they report to the GNSO, which is the governing body for new GTLD, which is the new GTLDs like .bar and .rest, you know, .pizza. And so that's affecting the policy in terms of from branding and from trademark perspective into policy. So you're asking me, that's what I've been doing mainly with ICANN, and also, of course, advising GTLDs when they need it.
Right. So on the new GTLD program, have you heard any concrete dates, or they're still thinking 18 is going to be the next round?
I think that they're looking at 18. I mean, right now, there's just the very beginnings of a WHOIS discussion on how they've been discussing about WHOIS accuracy, but there's been more discussion about it because people can lie on their WHOIS records. They're trying to figure out a way to authenticate, which can make it very difficult. There's also the issue of not necessarily GTLDs, but the issue of two-letter dot whatevers. Two-letter dot whatevers has been a big problem because there's a government advisory council known as the GAC, and there are country codes. There are country codes like Montenegro is .me, but also if somebody had me.pizza, are they copying the name of a city or country that's governed or protected by the United Nations? So that's consideration. But as far as the GTLD program, there is discussion already. They're talking about changing some of the applicant guidebook, but really the big issue has been the transition from of the Internet or the IANA away from the United States and to someone else. That's been the a big issue. The cross-working group has been working on it. IPC has been commenting on it and providing their input as well. So that's about all that's really been talked about.
Okay.
Can I
Before
follow
we,
up on that real quick?
hang on one second, Aaron. Before we continue, whenever Karen goes to answer your question, can you mute your volume because there's a little feedback coming in from your phone. Do you mind?
On my phone?
Yes. Whenever
Okay.
Karen, yeah. So
Yeah, that's fine.
you ask and
Put her on
then
the
you
read
mute.
again,
Yeah, the last question I have, Karen, is there any way that you might want to suggest to ICANN about maybe opening up some type of round for brand owners? You know, folks like Facebook and stuff like that. I think they really missed the boat on this GTLD program, and you know, obviously, I'd like to see one come along with my brand, of course, and I think brand owners would be a good round to have. Not necessarily open it up for everybody, but brand owners in general.
Well, the IPC represents brand owners as well. And I think that there's concern among the brand owners that, particularly with the WHOIS information, the way that things are being governed, and I think that this is all a prelude to the next round. And I agree, you know, look, you could certainly try and join the IPC, by the way. There's nothing stopping you from applying. We're always looking for members. I'm a fairly new member, and I can tell you it's quite a lot to take in. But the obvious thing is ICANN would be delighted to have brand owners because it means more money for them. And, I mean, what do you mean specifically by brand owners? Do you want to create a different group within ICANN that represent brand owners?
No, what I'm saying in general is in 2012 they just opened it up for, you know, anybody that wanted to run their finger through the dictionary and pick out any term they wanted.
Yeah.
But now that all those terms are pretty much used up by donuts, you know, there's not going to be a lot of great short TLDs that anybody's going to be paying for. So really, I think they should have an option for brand owners, you know, Facebook, you know, Apple, I think, you know, brands like that are looking to apply.
Well, I think that this first round has been a huge experiment. And you might have noticed that several of the brands dropped out. GM dropped out a couple of their applications, and I think they just really didn't understand. They were thinking, oh, it's like registering a domain name defensively, so no one else can squat TLD. And most of these brands haven't even launched yet. So it's hard to say at this juncture whether really brands are going to be getting anything out of it. I frankly would like to see a real brand launch, a real marketing campaign using GTLD, because that's only going to help everyone in the program. It's going to get the word out to the consumer to get used to seeing that right at the dot. I mean, the GTLDs, the generic GTLDs are doing great. They're doing the best they can, but they're really stretched in terms of marketing dollars. I mean, a lot of them have won auctions, and they're using that to fuel marketing for their other names, but the brands are really the ones I think that are going to get the ball rolling. So I think maybe it's a little too early, that maybe in the next year we'll start to see the GTLD, brand GTLDs, really using it. And I think at that point, if it's successful, then the other brands are going to want to coalesce and really get more, have more interest in applying and learning from others on how to use it.
All right, thank you.
You're welcome.
Okay, does anyone else have a question for Karen?
Yes, hi Karen, this is Ashwin.
Hi, Ashwin.
How are you doing today?
I'm doing just fine, thank you. It's snowing in New York right now for a change.
Well, I have a few questions.
Sure.
And here is like, if someone is planning to file a UDRP, will he approach me before doing that? I mean, here's some email or...
And he approached you, did I lose you?
I'm sorry, if someone is planning to file a UDRP, Like, will they approach me before that via email, or how would that work? I mean,
Oh, it happens. That's usually the way it happens. They'll send you an email, and they'll say, "You better stop or else." Uh, that's usually the way it happens. In other instances, you'll be in some sort of domain sales platform possibly, and somebody will be quote-unquote negotiating a price for the domain name, and then they say, "You're a cyber squatter." And then it's met with a cease and desist. I mean, a lot of them are full of it, right? You know, a lot of them just don't really. They're just playing a game to try and talk you down in price, and it depends on who they are.
I see. So,
Email.
sorry. So now, like, you know, if someone comes to me and tries to threaten me for a UDRP and tries to do a negotiation for a domain, would it be like, you know, a lot of people, they come to me and they might just threaten me for a UDRP and want to buy the domain for cheaper price, right?
Yeah.
So,
Yeah.
how much would it cost for them to file a UDRP, the bare minimum, so that, you know, if it takes 5K, I might want to buy it for, they might want to buy it for 2K, example.
Yeah. Yeah. No,
So
fair question. Very fair question. If the person threatening you, who we would call the complainant, it doesn't hire a lawyer, and they do this on their own, okay, just out-of-pocket costs, to file a UDRP in the National Arbitration Forum for one panelist is $1,300. Then if they go to WIPO, it's $1,500 for one panelist. That's without any lawyer's fees. Okay? They're paying a lawyer on top of that, you know, $4,000, maybe $5,000. Some lawyers are even more expensive, like my good buddy John Berryhill. He won't tell me how much he charges, but I'm guessing he's pretty expensive. But the going rate's about $5,000 for a UDRP. And then adding that to the filing fee. So, you know, $6,000-$7,000, maybe more. But there's a lot of idiots out there too. I mean, they're like all bent on cyber squatters. They think all of us domain investors are cyber squatters. They don't understand. So, and you know, one of the things is, like, recently I had a situation with a client where they were using it as a tactic, and they had no foot to stand on. And they, you know, client brought me in, and I wrote a really special response letter to them. And they threatened and they threatened and they threatened, and so far they haven't really come through. So sometimes having a lawyer, you get the benefit of an extra leg up. And I'm saying this without being specific, but, you know, look, when you're an experienced lawyer, you know what you're doing, and somebody comes around and they want to accuse you of being a cyber squatter when you've done nothing wrong, you know, it's wrong. But it's also a matter of, right, if it's a $2,000 domain name and they're threatening you, you know, you have to make that call. Do you want to just hand it over to them for less money, or would you rather just say, go kick rocks, you know?
I see, I see. Thank you so much for that, Karen.
You're welcome.
Okay, I think that we have another question here. Let's see, from Pankaj. Is that how you say it? Are you there?
Yes, I am.
Hello.
Can you hear me?
Yes, we can hear
Hello. Okay. Fine. Well, first of all, hello to everyone.
you. Hello.
And Karen, Karen, I had a question that what happens if a registrar, even after an order to transfer the domain, is not willing to honor the order? I mean, even if the registrar does not transfer the domain name even after a successfully won UDRP case, in that case, what are the things that can pressurize the registrar to honor the orders, or what are the consequences that a registrar can face?
Are you saying, let me understand your question. Are you asking if you lost a UDRP and they refused to transfer the domain name? I didn't quite follow you there.
Exactly, that's what I've been asking. Suppose someone won a UDRP,
Right.
and it has been ordered to the registrar to transfer the domain to the trademark owner, but the registrar is still not willing to transfer the domain.
Mm. Yeah, if the registrar is refusing to transfer the domain name, that's a violation of ICANN policy. It's written in the policy that the registrar is immune from any liability if they cooperate with the system. Because usually what happens is when a UDRP is filed, and even when there is a lock that's placed on the domain name, as you may know, so you can't transfer it out. And then when there's a decision rendered, that decision goes from the arbitration company to the registrar and tells them, you need to unlock this. Send it to whoever won, right? If the registrar doesn't cooperate, they could be found liable for not cooperating and also lose their accreditation. Now, not every registrar is accredited by ICANN. So if that happens, they're equally at fault as the losing party. Has that happened with you?
Not exactly, but I have a friend who had an Indian registrar who didn't quite cooperate even after getting the orders to transfer the domain to the alleged party, and the case is still pending in the judiciary system.
This is a case in India, yes?
Yes.
Okay. And it was in the courts in India. It was not an arbitration.
Yes.
Yeah. Well, that sounds like a very difficult situation. I'm sorry to hear about your friend. Unfortunately, I really can't speak to Indian trademark law. But ICANN was it a .com domain or was it a .in?
No, it was a .com domain.
Huh. Because, ICANN does have authority over .coms, but not over country names like .in. So it seems to me that if that's the case, then it sounds like a mess. And now somebody's going to have to sue the registrar company. And oh boy, that just sounds terrible. I'm so sorry to hear that. I don't know how. The only thing that ICANN could do, or the only thing that your friend could do, better off, is not go to India, but come to Virginia in the United States and bring what we call an in rem proceeding, which is a form of an ACPA case, an Anti-Cyber Consumer Protection Act case, against the domain name, not the defendant, and explain that there was a written order for transfer of the domain name, and most likely the defendant registrar will not show up in court in Virginia. You'll get a default judgment with an order from the court in Virginia, in the federal court, that will say this domain name needs to be transferred, and you take that order to VeriSign, which is in Virginia, and they will release the domain name to the rightful owner. So if you need help, please contact me offline. I'll be happy to help you.
Okay, well, that brings another question. Does ICANN have the power to pull a domain name forcefully from a registrar and transfer it somewhere else, or ICANN doesn't hold any such power?
Yeah, well, that's the reason I was suggesting to go to Virginia and bring the case in Virginia, because ICANN doesn't have authority to order transfer of a domain name. It's the registry, and in this case, it's .com, which is VeriSign, that's located in Virginia. So you'd be better off. Your friend would be better off going to Virginia. I know it's far away from India than going to India, because you might get faster relief in the United States than India, and you would go straight to the source, which is the registry, with an order.
Okay, so that cleared it all. Thanks a lot, Karen. Thanks again.
Thank you, Karen. So So far, I don't see any other questions in the chat window right now. So I'm going to just tell you, Karen, this has been an excellent chat filled with great information, and I know what I need to do personally to protect myself, and I really just appreciate you taking the time to come out, well, to come on and chat with us today, and I hope that you'll come back.
I'd be delighted to, anytime.
Great.
Good questions, guys. Great panel.
All right, so Karen, I'm going to let you go, and anyone who wants to, I always stick around for about 10 to 20 minutes after, maybe even longer if the conversations get really good, and we can talk. Also, for anyone who's listening, these chats are recorded, and they will be converted afterwards, and we'll post them to the group wall. So thank you all.
Great, and also